The facts which the court must resolve. These are the facts in issue or the material facts that are directly related to the scenario or the occurrence of the case. The court shall only hear evidence regarding these facts that are related to the occurrence, but evidence might be direct or indirect. A court is only concerned with determining the material facts of the case. It will only hear evidence that is directly or indirectly relevant to those facts. In criminal case, the facts in issue are determined by reference to the element of the offense charged and any defense raised. The case may be fascinating for all sort of other reasons. Maybe there are other branches to the case that might not be relevant. But the court will confine itself to the evidence which relate to the facts of the occurrence of the case. So in the burglary case in which someone stole the money, the facts in issue are the defendant. The prosecution must prove who did it. The defendant entered the building as a trespasser, appropriated the property belonging to another with the intention permanently to deprive the owner thereof with the dishonest intention. All of these are facts of the case, and the prosecution has to give evidence to those facts in order to prove their case against the defendant. In most cases, these defense will simply involve denying being the perpetrator or disputing one or more elements of the offense. So the defense might run as, so the prosecution is saying that the defendant has done it, and the defense could take the plea that it wasn't me, and it could also say that I admit I stole the car, but it wasn't a burglary. The guy invited me into his house. So it could say that it wasn't done with a dishonest intention. The prosecution has to prove it that it was with the dishonest intention. So it could also say that it was my ex-wife's house. I just broke in to get what is rightfully mine. So in all of these scenarios, the prosecution has to give evidence that that person has done it with a dishonest intention, and property belonged to someone else, not to the defendant. Sometimes the defense will raise a specific defense which then becomes an additional fact in issue. If, for example, these defense is that he committed burglary under duress, under threat, like he was threatened by someone else, that duress, that threat becomes a fact in issue. So then the defense has to prove it that he was under threat of someone. That's how the burden of proof transforms and turns to the defense. In the cases when that defendant takes a plea that I did it because of this, then he has to prove it that that duress or the threat was duly the reason because of which he did the burglary.